If we could have quiet in the courtroom, please. The Honorable, the Supreme Court.
Morning again. Thank you all very much. Please be seated. And when you're ready, please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Tammy Kirshon et al. Versus Angela Abodeely-Mills and Jonathan Abodeely et al. Case number 25 AP146. Representing the appellants, Angela Abodeely-Mills and Jonathan Abodeely et al. Is attorney Aaron Miller-Hines. Representing the appellee, Tammy Kirshon et al. Is attorney James Town.
Thanks very much. Good morning, counsel. We'll hear from counsel for the appellant first, please. Come on up. And before you start, if you would introduce yourself and your client for the record.
Sure. Good morning. May it please the court, Aaron Hines from Lang Roxbury and Wool on behalf of the appellants, Jonathan Abodeely and Angela Abodeely-Mills.
Thank you.
The parties to this appeal are all cousins, and they are all descendants of the same woman, Hazel Rathbun. What the issue before the court is, what is the cousins' ownership interest in a summer camp property located at Lake Sunset in Benson and Orwell, Vermont? While the cousins disagree about what their ownership interests are, they do agree that their ownership interests are controlled by two deeds for the property. The first is a 1958 deed from Thelma Lilly, the Orwell town clerk, to Hazel and her three sons. And the second is a 1977 deed in which Hazel conveyed her interest in the camp property to those three sons. Appellants contend that the 1958 deed conveyed the property to Hazel and her sons as tenants in common, which, as the court knows, means that it can be transferred to each of the grantees, heirs, and assigns. Then,
if we agree with you on that point, what role does the 1977 deed play, if any?
if you agree with me on that point, then the 1977 deed is very straightforward. And when Hazel conveys her 1/4 tenants in common interest to the three sons in 1977, the sons' ownership interest increased from 1/4 to 1/3, and they continue to own it as tenants in common. It's very straightforward.
But Attorney Miller, if we agree with you, though, that the 1958 deed is a tenancy in common, then we don't even have to reach the 1977 deed, do we?
Well, this court would have to reverse and if you reverse and remand it on the 58 deed, you would not have to do anything with the 1977 deed because everybody agrees, I believe, that the 1977 deed conveyed a tenancy in common.
So Ms. Hines, doesn't the 77 deed just clarify what occurred in the 1958 deed?
Does it clarify what occurred in the 1958 deed? Well, as I just said, if you read the 1958 deed as conveying tenancy in common interest to Hazel and her three sons, then the 1977 deed just augments the son's interest by conveying Hazel's interest to the three of them. So they go from 1/4 to 1/3.
But the 58 deeds doesn't talk about joint tenants. It does talk about joint tenants. It doesn't talk about tenants in common.
Well, let's talk about that for a minute because the 1958 deed should be read as conveying a tenancy in common for a number of reasons. The first reason is that the grant clause does not have any language of joint tenancy at all. And where a clause has no language of joint tenancy under Vermont statutory preference for tenancies in common over joint tenancies, the court would have to find that the grant clause conveys a tenancy in common.
Well, if I could just interrupt you there, you're referring to the statute when you say the preference, when you're talking about a preference?
There's both. So the statutory preference is in 27 VSA section 2A.
It's a presumption, right?
It's a statutory preference. It says if there's no language of joint tenancy, then it must be read to be a tenancy.
But the trial court found that the facts overcome the presumption?
Yes, I think the trial court found that incorrectly because, as I said, the grant clause contains no language of joint tenancy at all. And then when we get to the habendum clause of the 1958 deed, that clause is internally inconsistent in that it contains both language of joint tenancy and language of tenancy in common in the same clause. Specifically, it says joint tenants with right of survivorship, which is the joint tenancy language. And then it combines that with their heirs and assigns forever, which is the tenancy in common language. And this court has said in Kip v. Chips Estate that using that additional language, their heirs and assigns forever, is inconsistent with a joint.
The KIP isn't four square with the facts here, is it?
It's as four square as we get. I mean, it's a pretty direct precedent for this case.
That was going to be my question. You don't quarrel with the reasoning in KIP at all, I suspect.
We do not quarrel with the reasoning in KIP, and I can explain why I think it's on point with this case, is that the internal inconsistency that we have in the habendum clause of the 1958 deed here is almost exactly the same as the internal inconsistency that was in the deed in KIP that the court found to result in a tenancy in common. Specifically, both the 1958 deed habendum clause and the KIP deed contain that joint tenant language in the same phrase as the their heirs and assigns forever. And when this court looked at that language in KIP, it said that that additional inclusion of the language, their heirs and assigns, even following the joint tenancy language, led to a tenancy in common.
Right, it's the word there.
Yes.
That's what you like.
Yes, the KIP court, this court in KIP, highlighted the importance of the word there. And it's an important word to look at here because in a joint tenancy, the interest never passes to their heirs and assigns. It only passes to the heirs and assigns of the surviving grantee. When the word there is in the phrase, even following multiple people, multiple listings of names, that can't be consistent with a joint tenancy. And in this case, it's particularly notable because the trial court completely disregarded the word there in the summary judgment decision. And that discussion is at page 5 and 6 of your printed case. The trial court only looked at heirs and assigns and completely disregarded the word there. Particularly important because the trial court went on to say that we have to give more importance to words that are typed in or written into a deed than the ones that are pre-printed on the form deeds. And in the 1958 deed, the word there is specifically typed into that deed. That's at page 91 of your printed case. You can actually see that the people preparing that deed in 1958 specifically added that word there. So it would be inappropriate to disregard that word there in the analysis of the 1958 deed. KIP's also important because in KIP, this court said, I'll get you the quote, "We can find a joint tenancy only if the intent to convey that property interest is expressed in clear and definite terms." Here, where we have a grant clause that contains no language of joint tenancy at all, and then a habendum clause that is internally conflicted and uses language that this court has said is internally inconsistent with a joint tenancy, we cannot find that there is clear and definitive terms of joint tenancy in the 1958 deed. So it must be read to convey a tenancy in common.
You know, one of the cases, and it may have been KIP, but perhaps you could help me with this, that use the words mild priority in terms of characterizing the preference. Is that KIP? Was it in KIP? Do you remember?
I don't recall mild priority.
Well, my question is that how you would characterize the presumption that's created by statute here?
Not at all. I think it's a stronger presumption than a mild priority. The statute specifically says, if we do not have these particular phrases, joint tenants with right of survivorship, we cannot find a joint tenancy at all.
Any idea why the legislature did this? We don't have any legislative history, and I haven't looked for it, but
I think if we go back to common law, there was a preference for joint tenancies as the preferred form of property ownership, and that has changed not just in Vermont, but across the country, where states have adopted these statutes that have the statutory preference for tenancies in common.
in order to protect successive generations?
It's to allow for the alienability of property rights. In a joint tenancy, the grantees do not have freely alienable rights, and the legislature in Vermont has said that we want that alienability to exist. It's not just in 27 VSA Section 2A, it's also in the partition statute, which I think we also cite in our brief. But in Vermont's partition statute, which is 12 VSA 5161, the legislature has allowed for joint tenants to sever their interests from their other joint tenants through a partition action, despite the survivorship attribute of the joint tenancy, which demonstrates, again, the legislature's preference for the alienability of joint tenant rights.
Ms. Hines, can we assume that in 1958, when this deed was drafted, there were no title standards in place?
I don't know that we can assume that. I think it was different than it is now, but I don't know that we can assume
That
that.
there was a statewide standard that was used or anything, or was just where we drafted?
The 58 deed?
Yes.
Well, again, we believe Thelma Lilly, the grantor of the deed, was the Orwell town clerk. And in all likelihood, it was part of a straw man transaction. But it was typed in by somebody. And yes, I think it was probably in precise drafting.
I couldn't see whether that was from a tax sale or from a straw transfer. But you're assuming, again, I don't mean to put words in your mouth, but you were assuming that it was a straw transfer?
Yes, I think it was common practice at the time for the town clerks to perform that kind of function for people. And I think the deed preceding the 1958 deed is also part of the record, but I'm not positive about that. But yes, so the town clerk would have somebody conveyed the property to the town clerk, who then conveyed it right back out to Hazel and the three sons, which is how we get to the 1958 deed. That's at page 91 of your printed case. And in this case, the property happens to be, it straddles Benson and Orwell, so it also straddles Rutland and Addison County. So there were a number of subsequent deeds filed because of that.
So is that why the deed says something that Hazel has conveyed? It says all that in the description of the 58 deed, it says all that property that was conveyed by Hazel, and it gives and then it's to her.
Yeah, I think that's the straw man transaction. And you're probably looking at the second.
You see the time, I don't mean to interrupt you, but
I do see that, Your Honor.
Okay.
So let me just briefly address the 1977 deed, and then I'll reserve my remaining time for rebuttal. With respect to the 1977 deed, if the court agrees with us that the 1958 deed conveyed a tenancy in common, the analysis is very straightforward, and the 1977 deed just increases the three sons' interests as tenants in common. If the court disagrees and finds that a joint tenancy was conveyed in the 1958 deed, the court should nonetheless find that the three brothers ended up with 1/3 shares following the 1977 deed, because that deed was an overt act that would have severed any joint tenancy that existed at that time. And while there's no Vermont case law directly on point as to whether a conveyance by one co-tenant to her other co-tenants would sever just her interest or the overall interest in the property, we believe that it is more consistent with Vermont existing law on concurrent property interests to say that the 1977 deed severed the entire interest and not just Hazel's 1/4 interest, as the trial court found. Otherwise, you end up with this fractional dual ownership where the brothers continue to own their original 1/4 as joint tenants, and then they own 1/3 of their mother's 1/4 or 1/12 as tenants in common, which defeats the purpose of a joint tenancy, because the survivor of the original grantee never ends up with the entire estate. So we think that's inconsistent with the joint tenancy and inconsistent with Vermont law and the preference that the legislature has given us for tenancies in common and alienability of joint tenant rights. If the court has no further questions at this time, I'll reserve my remaining time.
All right, thank you very much. We'll hear from counsel for the appellee, please. Come on up, and before you begin, if you would introduce yourself and identify your client.
Good morning, Your Honors. My name is James Town, and I represent the plaintiffs in this proceeding.
Thank you.
Tammy Kirshon, Terry Brooks, and Tanya Dudley. They are the daughters of Ernest, who was a 1/3, one of the three brothers who took title back in 1958 with their mother.
He was the last surviving son, correct?
I look at the 58 deed as being very clear. The granting clause does nothing to define the individuals in question, but the habendum clause does. And there is certainly long history of habendum clauses, even having such import with respect to a determination of any specific title given to the grantees in the granting clause. It's not only guidance, but it can be controlling. So to dismiss it as, no, this is a tenancy in common because nothing is referenced in the granting clauses, ignores, in my mind, the state of law with respect to the power that the habendum clause.
But Mr. Town, I mean, when you look at the wording, it says joint tenants with right of survivorship, Then it says their heirs and assigns forever. How do you justify the joint tenants with their heirs and assigns forever? Aren't they contradictory?
Excuse me, Your Honor, the addendum clause has two instances where it's stating that it's joint, and that is defining them as joint tenants, and then goes on to say, which it didn't need to do, with right of survivorship. With respect to their heirs and assigns, I look at it as that is an error, and that's not what was done.
Right, but if there's any ambiguity here, don't you lose?
No,
If there's ambiguity.
actually, I believe the reverse, Your Honor. I think that if there's ambiguity and you adopt the appellant's position, you're opening up a very unique area to potential pandemonium. And that is, I'd like to define that within what we're all doing here and what attorneys do and judges. We want to come up with standard rules so that there are things that people can follow. As Judge Cohen pointed out, title work has certainly changed the practice of law with respect to real property transactions and gives great guidance.
But isn't a excuse me for interrupting, but isn't one of these rules that the expression to create a joint tenancy must be clear and definite?
I believe it is. It states
So I go
joint.
back to my question. If there's any ambiguity, don't you lose?
No, I don't believe so. I read the addendum clause as being very clear what it states.
But you're just elevating the survivorship language there and not paying attention to the other language, the their and heirs and assigns.
Well, first of all, the word there does not deal with the ownership interest. It has to do with the individuals in question. It's defining them. It's a plural pronoun, and that's what it's doing. That's what it services. I think you should ascribe any greater significance to the word there than the fact that it's just a plural pronoun.
But except they're four owners in 1958. They have four owners and their heirs. E-H-E-R, not, so it's plural. So all four of their heirs.
Again, I believe that the word there relates back to the fact that there are four individuals, and that's why it's a plural pronoun, and it's limited to that simple function.
But Attorney Town, isn't your analysis essentially disregarding the, or I'm sorry, it's not permitting the deed, the whole deed, to speak for itself. What you're really doing is just disregarding the granting clauses, lack of intent to create whatever tenancy, a joint tenancy. We have to consider the deed as a whole and not just focus on one phrase, especially when the granting clause makes no language or states no language that it is a joint tenancy.
Again, Your Honor, I would disagree. The fact of the matter is the granting clause by itself creates a tenancy in common between the individuals where individuals are named and there's no ascribed positions such as tenants by the entirety or joint tenants. It defaults to a tenancy in common. It cannot create survivorship rights by error. So it's deemed an intentional act. But now you drop down to the addendum clause. The addendum clause is used for many things. One is to provide explanation as to what was intended in the granting clause. So again, it's not, there are instances where the addendum clause actually determines what the interpretation is with respect to, and that's what I'm saying here.
You,
Thank you, Chief Justice.
okay, I don't mean to.
No, I'm all set, Chief
Okay,
Justice.
you mentioned a few moments ago, and I'm not sure I'm using the same words that you did, but something about the intent of the law is to create rules of foreseeability.
Correct.
Why? Love that chime, but I don't think it's for us.
That's not to run.
No. Okay.
You have to get out of here.
Yeah. No, but what is it about your position that inures that interest, that goes to that interest? And what is it about your opponent's position that defeats that interest?
So with respect to, I understand the differentiation, but with respect to the 1977 deed,
Yeah.
what did that accomplish? The grantor on that deed destroyed, with respect to her interest, a joint tenancy. So she, at that point in time, before she well, put it this way, if she had deeded out to not her son, and I think unfortunately the court may feel inclined because of the familiar part of this. Of course, she would want to do this. It's her children. But there are plenty of reasons why she wouldn't want to do it. So for instance, her 3 sons were wonderful and she didn't do anything for her daughters. But then she thinks this is a great house and it got all this history there. Why don't she goes to see Frank Kingsley, who was an attorney in Whitehall, who's an excellent real estate attorney, and says, I feel bad, I left my daughters out. Okay, fine. What can you do? You can issue a deed to your daughters. And is that going to destroy the joint tenancy over? No, it's not. It's going to mean those ladies each get 8 1/3. So they have some tie to the property. Coincidentally, the same thing happens here. She pulls out, issues a deed back to her fellow joint tenants. And in doing so, she's passing to each one of them an 8 1/3 interest in her tenants, or joint, I'm sorry, in her tenancy common.
How do you get there? I can't, I have a hard time getting to that point you just made. And I know the trial court did get there, but I can't seem to make the connection in my mind as to there's 4 owners. She transfers her ownership to the 3 remaining owners. And wouldn't it just be a third with
No.
right of survivorship?
With respect to the interest that she deeded back?
Yes.
No, because it's coming back. All she had, let's look at this another way. The highest level or most defined level of ownership, of common ownership, is a tenancy by the entirety. And I don't know what you people did when you walked out of law school, but I remember asking the professor, what's that? Don't worry about it. It's just a joint tenancy between spouses. It's actually not what it is. There are specific reasons and there's specific benefits to tenants by the entirety. So there's clarity there. Creditors, for instance, can't get to one of the tenants by the entirety. Neither one of the tenants by the entirety can destroy it by issuing a deed. So that's the model of everything. Now we drop down to joint tenancy. Why would one departing joint tenant be empowered to destroy the joint tenancy of everybody else that they may have negotiated for? Whatever it is. She comes out as a tenant in common. She's a tenant in common with the 3 of them. They own an undivided interest in the whole. Their whole is 75%. He took out 25% of her ownership. Divide that by 3, it's 8.3. And now they're at 33 1/3, each one of them. That makes sense?
Well, but they include heirs, and heirs disrupts the intents in the entirety. The heirs have a right to inherit under.
Well, I'm going back to the fact that she is addressing something now with heirs. Normally joint tenant, last one survives, gets everything. When they took in 8 1/3 interest from the tenancy in common, they took that in as tenants in common. Whatever she had to give was divided by 3, so that every one of the brothers had an indivisible right to the whole. And in addition to that, owned 8 1/3 for their heirs and assigns. That's the benefit of doing it the way they did. I don't view this as a mistake. I'll be honest with you, when I first saw this, somebody screwed up. I don't think they did.
But it results in this crazy anomalous situation where you've got, fractional shares. I mean, you can see why the modern trend has been toward tenancy in common, because this is just, when I create situations like this, it doesn't make sense.
Well, that's one of my points. Clearly, the granting clause, if you just stop there, they're tenants in common. That's the clarity you're talking about. But now you got to redefine that when you look down below, and there are 2 methods of which a joint tenancy is defined. Joint tenants, clear, okay? And, sorry, one in my head. There's a second instance where a joint tenancy is ascribed based upon the language in the Abodeely-Mills clause. I think that it's beneficial for the court to stay with Judge Burke's determination. Obviously, I believe it was correct and well thought out and reasoned. But the other thing is, do you want to create an exception that, in my mind, is ascribed to this familial relationship? That, of course, she was a joint tenant in 1958, 1977. She wanted out for whatever reason. And so she jumps out and then she gives the deed back. And what did she do? She preserved her 25% divided between her 3 sons. And the fact that the last person they get the 75% ownership. They get 100% of the interest in that 75%. And they also have for their heirs and assigns, as do the predeceased joint tenants, an 8 1/3 interest. I could see that as somebody trying to rectify something that was incorrect. I didn't mean to leave my daughters out. I didn't leave our sons, grandsons, and great-grandsons to be denied access to this property. And quite frankly, in this particular instance, that's a lot of the behavior that's been going on. The litigation has to do with just those issues.
Doesn't that create a lot of confusion as to who owns what and how much they own? And how they allocate costs and how they allocate time of use? It's not a full-time home. It's a place that you can go in the summer.
It creates a lot of confusion. There's no question about it. But to create the least amount of confusion is not to take her joint tenancy interest and say it automatically gets divided by the three of them.
If you're right that she did this in 1977 because she left her daughters out and felt badly about it, or at least that's a potential explanation, why wouldn't she just convey her interest to the daughters?
She could.
But she did.
Maybe there were reasons. I don't know.
Maybe the reason is that isn't what she intended.
Well, certainly that could be an analysis that you could come to, but I don't believe you need to jump and make that decision for her, because I believe the law is fairly clear. If there are 4 joint tenants and one of them wants out, whoever they're deeding it to is irrelevant, okay? When they execute a deed, they instantly become no longer a joint tenant. So they are a tenant in common with the combination of 3 former joint tenants who between themselves remain joint owners with all the rights and privileges and problems of being the last one standing. That's my opinion of this. Everybody's got that quizzical look, and I apologize for that. I want to, if you don't mind, I have 2 seconds. So, first of all, not being patronizing, but I think this is unbelievable, the fact that you're doing this. I wish we did this in New York, and we don't. Once in a while, the appellate division will go to another courthouse to do it, but this is an outstanding thing, especially with the world it is today, for people to get involved in civics. The second thing is, I hope, and so far I haven't heard it, in the first argument, as one of the gentlemen was talking, 73 kids got up and walked out. And I was thinking, God, that happens to me. That's going to be the worst defeat I've ever had in court in my life. I just killed the place. And the last thing my opponent is, and I'm not being patronized, incredibly skilled attorney, okay? And it's been a pleasure working with her. She's a great fighter, and she's a great person moving this case forward in the direction for her clients. However, I do need to note for the court that she has a son and a daughter, as I understand it, in this school. And I really felt putting my back to the audience was really stretching things. Thank you very much.
Thank you very much,
Thank you,
counsel.
counsel.
Thank you very much. We appreciate that. How much time does the appellant have, please?
Appellant has 2 minutes and 59 seconds remaining.
How are you going to beat that?
Yeah, you're going to rebut that?
I'm not going to make any personal comments.
Yeah, all right.
But I do want to go back to Justice Eaton's question about if this is ambiguous, does he lose? And yes, he does. The law is very clear that if the deed is ambiguous, if we cannot find a joint tenancy in clear and definite terms, we cannot find a joint tenancy. That's true in the statute. It's true in this court's precedents. If there is any ambiguity, the appellees lose, and this court has to find that the 1958 deed conveys a tenancy in common to Hazel and her 3 sons.
And Attorney Miller, that is in KIP, correct? That is the holding in KIP.
That is the holding in KIP. And I think KIP gives 4 reasons why it can't find a tenancy in common. And I think the 4th was, even if we're not going to let extrinsic evidence in, because what would it do? If you can't find a clear and definite statement within the terms of the deed, then by definition, it is not a joint tenancy. And that's what we have here as well. We have a grant clause that says nothing about joint tenancy. And then we have a habendum clause that includes the very language that this court has already said is inconsistent with a joint tenancy. And for those reasons, it has to convey a tenancy in common. So the appellants are respectfully asking that this court reverse and remand the summary judgment decision that found the opposite and find as a matter of law that the 1958 deed conveyed a tenancy in common. And then the analysis of the 1977 deed is extremely straightforward. I'm not sure what the discussion was about the daughters. There are no daughters. Hazel simply conveyed her 1/4 interest back to those 3 sons, and all of their interests increased from 1/4 as tenants in common to 1/3 in the tenants in common, and that's how it should be today. Thank you.
Thank you. Please call a conclusion of the hearing.